This time we'll hear the case of Bradenton Group versus the State of Florida. Yes, sir.
My name is Thomas Egan. I'm here on behalf of Philip Purtney. He's an individual.
Mr. Egan, I apologize, but could you speak up just a little? I'm having a hard time hearing you.
All right, I'm sorry. I have some problems with my throat, and I think it sounds louder to me than it does to you, so I'll just speak loud. I'm here on behalf of the individual, Philip Purtney. This court's aware of this case because it's been around a long time. It's been around actually since 1994 in one form or another. As the court's aware, there was two civil lawsuits filed by Lawson Lamar back in 1994 seeking forfeiture under the RICO statute of bingo halls in Orlando and Osceola County. Then subsequently in 1995, there was a third case brought by the Office of Statewide Prosecution and the Attorney General's Office seeking pretty much the same relief, but adding to those two halls another additional 11 halls seeking forfeiture. In 2001, both the two civil cases filed by Lawson Lamar.
Does your client make the claim for damages for the wrongful injunction, or is that Mr. Mason's client?
That's Mr. Mason's client. But we appealed the two cases that we prevailed upon brought by Lawson Lamar to this court. But we also appealed the injunction that was entered in 1995 in favor of the Attorney General, which this court's already entered an opinion on, and then the Supreme Court subsequently entered an opinion on. What happened was, as the court's aware, they came back, in the face of a Florida Supreme Court opinion saying that, misdemeanor bingo violations cannot constitute racketeering. They used a provision of both federal law and the racketeering statute.
You mean in this case?
In this case.
All right.
Amended the complaint, and so what we had is the same case, but with a new way through the bingo statute. There is just a world of issues in this case. I'm not going to address them all. I just want to address a few of them, and I want to address a few of them that I think are important. Most important is what happened with the jury and the jury instructions. Because generally, as this court's aware, if the jury doesn't know what it's doing, the result is not something anybody can rely on. The issues that we raised, as this court's aware, we filed our own extensive jury instructions. Asked the court to consider them. The court.
Did you all ask for the jury to be instructed on what the bingo statute said?
Yes. Yes, we did.
Why did you all ask for that?
Because the prosecution did, and because that was part of their complaint, part of their charges.
But wasn't their complaint just RICO under the RICO statute?
Your Honor, it's going to beguile you if I explained how this worked, but the bingo statute is a misdemeanor felony regulatory statute that deals with.
But this was a civil action.
It was a civil action, but it makes.
Is there a civil remedy under the bingo statute?
No, there's not, but there's a.
So they sued for RICO, alleging that the bingo violations were part of the predicate acts, right?
The bingo violations were in fact the predicate acts.
Well, okay, I understand.
They were the predicate acts, but the counts, instead of being.
Called them something other than bingo, right?
They call them, well, actually, they referred expressly to 849.0931, but the federal statute, which is 1995.
But we know from the Supreme Court that bingo violations do not amount to predicate acts under the RICO statute. We know that, right?
We knew that.
Why did anybody ask that the jury be instructed on bingo as well?
Well, we knew that, and the Florida Supreme Court knew that, and I guess you know that. But rather than give a summary judgment on that ground, they decided that under federal law, because federal law has an open provision in it under federal RICO, that a violation of federal law can be proved by a violation of state law. And so they used the misdemeanor bingo statute to prove the violation of federal law. And because the very last provision of the Florida RICO statute provides that it has a list of predicate acts, the last one said any violation of federal law, so they pushed 1955 in and made a violation of federal law, which in turn was a violation of state law. It was very convoluted and hard.
Could they have, right out of the box, brought a federal RICO action based upon violation of the Florida misdemeanor bingo statute?
Yes.
So it could theoretically be a violation of the federal RICO statute.
Could, yes.
And the state statute says any violation of the federal RICO statute can be a predicate offense for the state statute, correct?
Yes.
And so your position is because of them having brought the earlier actions, that's what precludes it, not some theoretical argument that they could never bring it under the federal RICO, correct?
There are a couple of federal cases that provide for it. My sense of the law and justice revolts at the idea that a regulatory statute can never constitute a violation of a racketeering statute, especially in this context, because what effectively occurred here is that they have alleged, because of a violation of a regulatory provision of a statute by employees of a corporation, a legal bingo operation, otherwise legal in every way, legally, openly conducting itself. If one employee or two employees violate a certain provision of a regulatory statute, namely the compensation received by the hall workers, that constitutes grounds for forfeiture of the entire legal gambling business. In fact, if they find, like at a racetrack, someone juices a horse or something like that, which would be a violation of a state regulatory statute, certainly does not make the pari-mutuel or the racetrack an illegal gambling operation, but does that therefore subject the entire racetrack to forfeiture under federal law because a regulatory statute has been violated? Or,
what makes it a regulatory statute as opposed to any other kind?
Regulatory.
Because it allows some kind of bingo and not others?
It allows bingo. I mean, it allows commercial bingo in the state of Florida. There's a couple hundred bingo halls in the state of Florida operating today. Each of the halls that were allegedly closed by the state of Florida are still operating today, except they're operating by Americans.
So is the lottery statute a regulatory statute because it only allows a certain kind of lottery, such that if you operated an illegal lottery, you don't think that could support RICO because it's a regulatory statute?
The lottery statute is entirely different, Your Honor. This deals with the conduct of the games, the location of the enterprise, employees, who conducts it, who owns it, the rents charged. It's an extensive statute dealing with all manner of operation. The lottery statute is something entirely different. That comes from our Constitution. It's prohibited. Private lotteries are prohibited, except if they're, commercial enterprises that come within those realms. They're not allowed at all. So let me get back to the jury instructions. The most important one of these issues involving jury instructions was in the evidence. When we went to trial, there were some issues as actually what was racketeering. They introduced evidence that there was Vegas nights where there were free trip giveaways. There was all these promotions, lots of evidence about that. Lots of evidence about money changing hands and charities and the like. But they ended up with this issue of compensation for the floor workers. There was evidence during the trial that one of the area managers came in, an individual by the name of Marlene Clay. She testified, she was a state witness, she testified it was her idea to start putting money in the tip boxes to encourage these guys to clean up the building after they were through, to do janitorial services. She also testified, and 2 or 3 people testified, that in 1993, Mr. Fertney came down, he brought this fellow named Pat Savage. He wanted it cleaned up, he wanted this practice stopped. And it was stopped in 1993. Under the RICO statute, as this Court's aware, there's a concept called pattern of racketeering activity. It's a vague, undefined concept because, in general, it's hard to discern whether 2 or more acts constitute a racketeering if they're, have similar intent, similar victims. So anybody that commits 2 similar acts with another group of guys could be subject to racketeering, whereas what the courts consistently says, it takes more. It takes an element of continuity. And this Court back in Finwood, the Florida Supreme Court, and the United States Supreme Court said continuity is an essential element of a crime of racketeering. It has to be alleged. It has to be proved. There was evidence during the trial that what happened was when Mr. Fertney found out about this putting money in the tip box, he ordered it to stop. It stopped in 1993, 2 years before the civil RICO complaint was filed. Your Honor, this was a difficult case because the court's aware. The jury came after the jury was instructed. They first came back and they said, what's racketeering? We don't know what racketeering is. And then they came back and said, we didn't know how to assess any damages. The problem with damages is because unlike all other kinds of crimes, this was not a legal gambling operation. It was an operation where they were violating a statute concerning compensation for floor workers, that they were conducting bingo, that they were paying out prizes, all that stuff. That was completely legal. The jury had a problem figuring out how to assess.
What is it that you are arguing as far as the jury instructions? The ones you requested should have been given?
I think, Your Honor, that they had to instruct the jury on this issue of continuity, whether there's a continuing threat, because what the evidence showed, and we could have argued this to the jury, that Mr. Fertney found out about it in 1993. He met with Pat Savage. There was evidence of that. 3 or 4 witnesses testified. They put a stop to that. Anybody that was doing janitorial service.
Tell us about whether or not this case is viable because of the previous cases, that is, Bradenton 2, the Lamar case. Why is this case not improperly brought? Because it has been resolved by prior courts.
Besides my brief, this is I can't explain it. Why the Lawson Lamar filed these 2 lawsuits, and then on top of that, why they allowed these lawsuits to continue all the way to 2001, and then the state of Florida filed a 3rd lawsuit. They take the position because it's the AG office on one hand and the state attorney on the other. It's not res judicata. It's not issue preclusion. But if you look in the Predicate Acts 1 and 2 deal with Osceola and Orange County. We asked the judge, one, not to admit any evidence concerning that because we'd already obtained a judgment. They should not have tried Mr. Fertney again for a case he'd already won. Either the issue should have been precluded, that evidence should have been taken out, or the jury should have been instructed, by the way, he's already prevailed on this, the judge is already in a judgment, this should not be in this case. Instead, they went ahead with it. We think, and I think the law is this, if you file a lawsuit in racketeering, or any kind of lawsuit, and there are other causes of action that you can or should be bringing, they ought to be brought. This case should have been brought as 1 case, not as 3. And why they let this case go to judgment and then proceed with this other case, I don't know. But I think, Your Honor, it's a clear case of res judicata. They take the position that, well, we've got 13 halls in one and 2 in the other, but the one involving 2 was the one that was brought in 1994. It either should have been dismissed or something should have been done with it when they allowed it to go to judgment. The issue of whether or not he was conducting racketeering in 1993 and 1994 should have been decided in his favor. Why? I guess there's some kind of interagency squabbling over who was going to do the forfeiture, and I guess it was also a matter of money.
Why are y'all entitled to damages?
Pardon?
Why are you entitled to damages?
We didn't ask for damages, sir. Those damages were asked for by the corporations. That was under...
Is Mr. Mason going to argue at all?
Will address that. The other jury instructions, let me go over a couple more. The other jury instructions we asked for, one of them...
Are you going to yield some time to Mr. Mason?
Oh, I'm sorry. Yes, I will.
We've got 6 minutes total time remaining.
Judge, would you give me some indulgence and allow me an additional 5?
Go ahead, we'll see how it comes in.
First, very quickly, I wanted to modify an answer relative to Judge Palmer's question regarding the possibility of prospective federal litigation based upon this bingo statute. And I've got to tell you, I think that's highly questionable, if not downright doubtful, that they could bring a federal case in the United States District Court based upon 849-0931 under the federal RICO statute. Now, has that issue ever been decided by the federal court? Absolutely not, that I'm aware of. But more specifically, I think it's questionable because of this. One is there's a number of cases construing other state statutes where people have violated a state law, Kentucky, et cetera. They brought federal RICO actions based upon another bingo statute. And the federal courts have said, look, we're not bound by state law or what state courts do. And specifically, if that statute requires some type of special or specific intent, we're not going to graft that onto our statute, and therefore we can ignore it, or it's simply not applicable. But here we have something bigger and broader than that. Here we have the District Court of Appeal and the Florida Supreme Court, as well as two trial judges, have found that the bingo statute, our specialized bingo statute, is an absolute shield, an exemption, an exception, an immunity statute, and you can never go outside of that statute and prosecute anything else. So if that issue was brought in front of the federal judge as a matter of comedy or just precedent, I doubt whether or not they could ever prosecute anyone under this statute in any forum relative to 849.0931.
And therefore, your argument is that as a matter of law, they don't meet the predicate act by alleging federal RICO violation any more than they do by alleging violation of the bingo statute.
Absolutely. 100%.
And do I understand that, at least as to these two bingo halls that were the subject of the earlier statute, their theory in this case was the same facts, just a different legal theory?
Yes.
These facts violated the bingo statute, therefore it's RICO. That goes up. The court says, no, that's not RICO. So they say these same acts constitute violation of the federal RICO, which becomes the predicate act for the state action.
Yes. And to distill it even down to its narrowest point, when we litigated this at the trial court, their argument was, we're not the state of Florida. We're an entity called an agency of the state of Florida, and therefore the res judicata, issue preclusion, no procedural bar applies to us. When we got up to the District Court of Appeal, that became a footnote and no longer was the heart and soul of their argument, and their argument changed, and they said, no, we can go through 895 and we can pick out any theory, any predicate act under 895, and each one of those constitutes an independent, separate cause of action. And about 10 days ago, give or take, was a case came out called Lehigh, which you have not seen. I filed a supplemental authority this morning, faxed it to the state yesterday afternoon, and talked to them about it this morning. And in that case, the court says a theory is not a cause of action. If your cause of action is negligence, then every theory is subsumed and embodied with that. If you're suing for breach of contract, and this is the four corners of the contract, then your claims have to be brought, and you can't piecemeal your litigation. And that's exactly what they did here. They just sort of reconverted the theory, and they called it a cause of action.
Is that done on a splitting the cause of action kind of theory, as opposed to a law of the case or collateral estoppel issue?
The Lehigh case, they talk about it, and they say, well, either, there's some sense of confusion about terms in terms of art, and whether it's splitting cause of action or it's res judicata, but they distill it down, and they say, irrespective of what you want to call it, you can't do it. And in that case, it was a breach of contract, breach of lease case, and they said you can't come back with different theories after you lost. In that case, it was a judgment, went up to the District Court of Appeal, lost, and came back and reconfigured the claim, brought it under another theory, but based upon the same lease, and the court tossed it and found that, no, you're not entitled to multiple bites at.
What court was that?
The 4th District Court of Appeal, and it came out on May 2nd is my recollection. I have a copy of it here.
You served a copy on your opponent, and that's, I understand, by fax to him and files today.
Yes, sir. So I do not see.
I'll give an additional 4 minutes, sir.
Thank you, sir. I do not see how this case can be.
Let me ask you about the damages, Mr. Mason. Now, apparently, based on the jury verdict, they found that your client violated the bingo statute. Whether or not that amounts to a predicate act of the RICO statute, I understand, is debatable, but you violated the bingo statute based on a jury verdict. Is that right?
Yes.
As I understand your argument on damages, or one of your arguments, or maybe your central argument, is that the injunction was overbroad because it prohibited any bingo operation, whether licit or illicit. Is that right? Is that your argument? Okay. Now, in terms of damages and your damage theory, your client operated an illicit bingo operation. It would not be entitled to recover profits, lost profits, based on an illicit bingo operation, right?
assuming you uphold this judgment and this verdict, then it would seem.
Well, even if we say that there's no RICO violation, you can't ignore the fact that, you know, there was a jury finding that they committed violations of the bingo statute. I assume that they're not entitled to recover as damages ill-gotten gains when they're violating the bingo statute, right?
It depends upon exactly what you mean by that. Our point is, if the injunction in November 1995 would have been entered, I mean, this was such a simple case at its heart that became extremely complex, and would have said, look, if you want to pay these folks for cleaning up the hall $20 or $50 or $1,000, so be it. Pay them for that, but don't put money in a jar that's designated for tips. You're entitled to tip. You're not allowed to put beyond.
I mean, they made numerous allegations of violations of the bingo statute. One of them was that they were not legitimate charities. Wasn't that one of the arguments that they made?
Judge, the charities in this case loved us.
Well, that was one of their allegations, wasn't it? And I read it somewhere. I didn't just make it up.
They put on
That they weren't legitimate charity workers, I think, was an argument.
One single witness testified.
Okay, well, let me. I want to try to keep this as simple as I can, Mr. Mason. Is your client entitled to recover as a component of its damages for the wrongful injunction entered, lost profits from a bingo operation that would have been in violation of the regulatory statute?
Yes, because the injunction did not stop us, so to speak, from conducting illegal acts specifically, meaning don't add any money to the tip jar and make sure that everyone is signed up as a member of the charity. The injunction said you're prohibited from the conduct of bingo. And the profit center in a bingo hall is that snack bar and that cafeteria. And once you can't have 100, 200, 300, 400 captive people in there, you're no longer selling T-shirts and candy bars and everything else. I mean, it's not a question of whether some isolated independent act, and they hate you.
Well, I accept the premise that if the injunction, at least for the time being, I accept the premise that if the injunction prohibited your clients from conducting legal bingo activities, and that was wrongfully entered, that they should be entitled to recover profits they would have made from legal bingo activities. What I'm having a difficult time understanding, though, is how they could recover from bingo operations that were in contravention of the bingo statute.
And I'll answer it this way.
People don't buy anything in the snack bar unless they come in to play bingo. And if the bingo that's going on is illegal bingo, then it would seem that any profits that were derived from that are not recoverable.
Answering this question on the fly, which sometimes is dangerous, I would say this. If you uphold the judgment and the verdict in this case, which I hope you don't, but if you do, and this case went back for an evidentiary hearing, do I think the state could make an argument, you're entitled to some damages, but you're not entitled to all the damages you want because we think we can parse out certain things that you did, that you specifically received money from that were improper, that would have fit within the confines of a specifically tailored injunction, and then we get into the amount of the nut, then I concede they can raise that argument. Do I concede that it's viable? I'd want to briefly.
Well, I'm not sure the burden's on the state to extract out that which would have been derived from illegal operations, because I think the burden is on you to prove the damages, the legitimate damages that you suffered as a result of the overbroad injunction.
Well,
I think you have that burden, right?
I mean, if 800 Inc. comes in and puts on its testimony, when it has nothing to do with adding $15 or $20 to a tip jar, and it's
You've got 1 minute left.
And its profit center is T-shirts and bingo paraphernalia, I think we could easily satisfy that burden. I don't see how a reasonable, logical fact finder, in this case Judge Johnston, who's a terrific judge, could disagree with us on it.
Which entities are seeking damages under the injunction?
All the corporate entities.
The one that ran the snack bar
Yes.
was one of them. The one that owned the property?
Yes.
Anybody else?
And the bingo entity, Pondella.
And how does Pondella get its profits?
It leases its hall, a fully equipped hall, to the charities at a profit. It leases the hall for 2 to 4 hours, no different than if you had to rent a hall for a wedding reception, and they charge them above and beyond what it costs them to renovate the hall, which is $200 to $300 or $200 to $300.
There was no finding in this case that it was rented for excessive rent, correct?
No.
There was some dispute in the briefs about
They
it.
never put on a witness, because how could you ever establish that? We all know from firsthand experience what it costs to rent a hall, much less a fully equipped bingo hall.
Thank you, sir.
Thank you.
Use an additional 4 minutes.
Thank you, Your Honor.
Let me ask you to start with the identity of party issue as it relates to either res judicata law, the case, collateral estoppel, et cetera. Is it your position that the entities that brought these actions on behalf of the people of the state of Florida do not have an identity of parties?
I think, Your Honor, the law is ambiguous on that, so it could be the same identity of the party. The state is asserting what the trial court asserted, which is that when they denied their motion for summary judgment on res judicata, which is that there was no identity of the cause of action. That's what, and
Okay, let's talk about the action, at least as it relates to the 2 halls in Orange County, or in the Ninth Circuit, that were the subject of the original action.
Before you answer Judge Palmer's question, I just want to know what your name is.
J. Andrew Atkinson on behalf of the plaintiff, the Department of Legal Affairs.
Thanks.
May it please the court. And your question again, Your Honor.
At least as to the bingo halls, which were the subject of the action in the Ninth Circuit.
Yes, Your Honor.
Were the acts that were alleged in the original action as violation of the federal RICO statute the same acts that formed the subsequent lawsuit, the only difference being a new legal theory, which is, well, they violate federal RICO, and that's how they violate the Florida RICO?
Yes, Your Honor. Yes.
So the exact same acts, the exact same facts were the subject of both lawsuits. You had to prove whether or not they were putting money in the tip. You had to prove whether these were legitimate charity workers. You had to prove the same thing. But we now have a new theory for why they're live, why they're violating the RICO statute.
Yes,
Is
Your
that
Honor.
fair?
For those 2 bingo halls for 9 months, that was the same 9 months of racketeering activity based on violations of the bingo statute. That was in the 1994 case. However, that pattern of racketeering activity is not the same pattern of racketeering activity that encompassed 13 bingo halls over the course of 4 years, from 1991 to 1995.
Well, explain to me something. You agree that the Bradenton 2 case decided by the Supreme Court said that bingo is not a lottery in Florida. Is that accurate?
Bingo is not a lottery in Florida, Your Honor.
And is bingo a crime in Florida?
Yes, it is, Your Honor. If you do it illegally, it's first offense is a misdemeanor. Every subsequent offense is a felony, punishable by 5 years in prison.
Did the Supreme Court find in this case, on these parties previously, that there was a crime committed?
The Supreme Court did not have any of the facts before. The Supreme
That's
Court.
fine, but my question is, did they find that there was a crime committed based
No, Your
on
Honor.
the opinion?
No, Your Honor, that wasn't before.
And in the Lamar case below, in the Ninth Judicial Circuit, did they find in favor of the appellants on other issues involving forfeiture, et cetera?
In Lamar, they granted summary judgment.
All right, sir. The same acts, then, you now say violate a federal statute involving bingo, I presume. Is that correct?
Yes, Your Honor. I mean, the federal statute doesn't involve bingo. It's an illegal gambling business, which the federal courts have based in a handful of cases on state bingo violations.
So then you must prove that bingo, or the bingo parlors they were running, was illegal under the federal statute?
No, the Section 1955, United States Section 1955, is entitled illegal gambling business.
Yes, sir.
And what it requires is that it's a gambling business in violation of state law. And
Then bingo is what they were doing, so that violates state law. That's your argument?
Yes, Your Honor, that they were systematically violating the bingo statute. I can give you a case that would
Well,
make
but really, the issue is whether bingo is gambling, right?
Yes, Your Honor.
It has to be a gambling business.
Yeah, the federal courts have
Violation.
universally held it to be a gambling business. Your Honor.
Pardon?
I apologize for interrupting.
No, tell me why.
The federal courts who have considered it have universally held violations of state bingo laws to be an illegal gambling business.
But apparently, the Florida Supreme Court says that a violation of the Florida bingo law is not gambling.
No, they didn't, Your Honor. That wasn't before that court. They decided that it was not a lottery. They said that the gambling violations of the bingo statute cannot be a lottery.
Didn't the Florida Supreme Court say that violating bingo is a violation of bingo, and you can't engraft that onto the lottery statute, which is essentially a gambling statute? Isn't that what the anti-lottery statute is? Isn't it a prohibition against gambling?
Yes, Your Honor.
I mean, isn't that the holding of the Supreme Court, that a violation of the bingo statute, the legislature intended in Florida, that a violation of the bingo statute is simply that, a misdemeanor or perhaps a felony, but only a violation of the bingo statute, not something else?
The Florida Supreme Court answered a certified question based on whether routine bingo offenses, in their words, could be charged under the RICO Act as illegal lotteries, and they found that it could not.
Could it be charged under any other statute as gambling, then, in your opinion?
It did not.
No, in your opinion.
Yes, Your Honor, and I would refer to multiple. I mean, just if I could, I think this will clear this up. United States v. Ables in the Sixth Circuit.
Is that a Florida law case?
No, this
Well,
applies.
that was my question. Florida law.
Your Honor.
Is bingo gambling in Florida?
Yes, Your Honor. There are cases.
From Florida?
Yes, Your Honor. I could, and I would be glad to provide supplemental on what.
So if a church or a Boy Scout troop does bingo, that's gambling, and they can be subject to forfeiture of assets because they may also be involved in a criminal enterprise. Is that your argument?
Yes, Your Honor. If they're diverting profits, what they did here was they diverted profits from the charitable endeavor for other purposes, and yes, they could be. There's multiple cases going back years.
What gambling statute is it that they violate?
The bingo statute, Your Honor.
No. The bingo statute is a separate statute, and you're saying that a violation of the bingo statute may constitute gambling under Florida law. I want to know what Florida statute you're talking about, what Florida gambling statute you're talking about.
Well, it would just be like the lottery statute, Your Honor. Violating the lottery statute is violating a gambling statute because just by a common usage of the term lottery, it's a gambling.
What statute are you talking about? What gambling statute?
The lottery statute, Your Honor. Illegal lottery is gambling by violating the lottery statute.
We seem to be going in a circle. First you said the Supreme Court ruled that bingo is not a lottery.
It is. I'm not contending it's a lottery. I was just answering Judge Torpey's question.
Well, the question as I understood it is, if it's not a lottery, what gambling statute in Florida did it violate if it's not the lottery statute?
It violated the bingo statute, Your Honor. Under Section 1955, the federal courts have universally held that illegal gambling businesses can be based on on state bingo practices. And as Judge Palmer stated, that is a RICO violation.
Apparently not in Florida. So this federal statute, 1955, says it has to be a gambling business, which is a violation of state law. Now, you got the violation of state law. I want to know how you prove it's a gambling business when the Supreme Court has said that a violation of bingo statute doesn't amount to gambling.
I respectfully disagree with your representation of the opinion of the
It doesn't amount to a lottery.
It doesn't amount to a lottery.
But it does amount to gambling.
Yes, Your Honor.
Okay, tell me the statute that prohibits it. Tell me the gambling statute that you rely on.
Well, I don't know what you mean by gambling statutes, Your Honor.
Well, you are supposed to enlighten us. You said it's gambling. So tell us which statute that bingo violates, if not the lottery statute. We know it doesn't violate the law.
I don't have any other answer to your question, Your Honor.
Well, what statute is it then?
The bingo statute, Your Honor. The bingo statute was constructed by the Florida legislature.
Well, didn't the Florida Supreme Court say that it's not a lottery, it's not and cannot be a RICO violation And until the Florida legislature gives us better details, bingo is okay in Florida.
Well, bingo is okay, but you can, it's a crime to divert funds from the charities to,
But it's only a violation of the bingo statute, and the Supreme Court said that cannot be a predicate act under the RICO statute.
well, the predicate act that was before the Supreme Court was under Section 1A of the Racketeering Act. That was lottery. The predicate act under 1B, which incorporates the federal, anything under federal law that's racketeering, was not before.
Well, they didn't make the right argument the last time around before the Supreme Court, right?
Well, that wasn't before the Supreme
The
Court.
government didn't make the right argument.
Well, the government didn't amend its complaint until the Supreme Court ruled on the lottery issue, and then afterwards they amended the complaint to go under a different
So
section.
is your argument that if you are charged with a subsection of a crime, let's say A, and are found not guilty, and it goes to the Supreme Court, on the same facts with the same people, you can come back and charge them under subsection B of that same statute?
The Florida Supreme Court was not a criminal action. It was this action. It was this same civil action.
Gambling is a crime, correct?
Yes, Your Honor. So is violation of the bingo statute, diverting funds from charities.
So answer my hypothetical about a crime.
Oh, I'm sorry. I thought you were talking about the Florida Supreme Court.
A crime.
No, a crime. So you're saying if a crime.
If they are charged under a criminal statute, section A, and they are found not guilty, what the Supreme Court says that is not a crime, can the state then come back, same party, same day, same predicate acts, and charge them under subsection B of that same statute?
I would think that it's possible that double jeopardy would apply, but this is not a criminal case. This is a civil.
Well, then what about collateral estoppel as an analogy?
Well, that would be.
Res judicata as an analogy.
Well, that would be law of the case because this is the same case. So in the law of the case, but.
Well, don't you have an identity of parties, identity of issues, identity of dates? And the 2 of the 13 counts, identity of locations?
There's no identity of the cause of action, Your Honor. This cause of action under 1B, which is anything chargeable as racketeering under the federal law, was never before any court.
Are you arguing that federal law preempts state law
No, Your Honor.
in bingo?
No, Your Honor. What I'm arguing is that if you read the cases cited in our brief that apply to almost identical scheme, I would point out the United
The
States.
statute in those states were not identical to the statute in Florida, and there was no ultimate ruling by a Supreme Court that said bingo is not a lottery and bingo cannot be used for RICO violations.
Well, that wasn't what I said, Your Honor.
This is a question of Florida state law, right?
Yes, Your Honor. I mean,
This 1955 says it has to be a violation of the law of the state,
it was, Your Honor.
and it has to be a gambling business
It was,
that
Your Honor.
violates the law of the state.
If you look at case
All
law.
those cases you got from, that say bingo in other states amounts to a gambling violation, they really don't apply here, right?
Your Honor, I think they do, Your Honor. If you would allow me, I would be happy to supplement you with historical authority for all these cases that talk about bingo as gambling. I mean,
I'm not sure that we really care about the law of any other state.
No, in Florida cases, Your Honor. Florida cases that consider bingo a form of gambling. I mean, it's just.
Wait.
I can supplement you with.
Now, those cases involve gambling halls, and they involve
bingo
bingo
halls.
and gambling halls. Prior to the statute being enacted that that is before us today. Is that correct or not?
That might very well likely have been before that, but I'm saying as the common usage of the term bingo is
So how does
gambling.
the Supreme Court case, then, that was decided in Bradenton 2, contradicted by cases prior to that, in your opinion?
Well, I respectfully disagree with if Your Honor is saying that the Supreme Court decision in this case, the prior Supreme Court decision, held that bingo is not gambling. I respectfully disagree. That's what the court said, Your Honor. They had a narrowly framed certified question before it based on the way that.
I agree with you, but my question to you and Judge Tarpon is, what then is the gambling statute that bingo violates? If it's not the lottery statute, and we know that's not the one, so which statute does it violate?
I have no other answer than the one I'm giving, Your Honor.
What is that then?
Your Honor?
What is that you have given before the answer?
The bingo statute, Your Honor. I have no other question. I have no other answer to your question, Your Honor.
So bingo violates itself, therefore it's gambling?
Yes, Your Honor, based on just the common usage of the term, based on prior Supreme Court, prior Florida case law, based on subsection 1B of the Florida RICO Act says anything that is chargeable as racketeering activity under federal law is chargeable as racketeering activity under Florida law. There are multiple cases in federal law that have said a 1955 violation can be premised on, and I'll say it here, the exact same type of scheme is what I'm saying, an illegal gambling business conviction based on operation of a bingo hall in violation of Kentucky law that operated under the guise that the bingo proceeds would be donated to tax-exempt organizations.
How do you square your argument with the specific language of the Supreme Court that says that bingo cannot be the subject of a RICO violation?
Well, I would say that is capable of different interpretations, Your Honor, but the one that's
capable of different interpretations.
Oh, because the certified question, because of the other language surrounding it.
I agree with the certified question, but the Supreme Court specifically wrote that it cannot be a violation of RICO.
It says under the lottery or, it's not punishable under the lottery or RICO statutes.
Right, Your Honor. The position of the Attorney General is that
they were just wrong on that because
well, I think
they didn't
because
understand the argument that was made or the argument wasn't made.
Well, it wasn't before then, Your Honor. I think given the
is that dicta right there where they say
I would say
punishable under the lottery or RICO statutes. Is that dicta, that part of the or RICO statutes?
Yes, Your Honor. Given that there is the plain language of all these other statutes, that opinion can be harmonized with the law of Florida, which states unequivocally by its plain language that it can incorporate federal causes of action.
So then any church, in your opinion, ostensibly could be charged with a RICO violation because bingo is gambling under the bingo statute. Is that correct?
Yes, Your Honor, if they did what the defendants did, which is what the defendants did. Well, firstly,
well, I mean, if they violated any aspect of the bingo statute, it would give rise to a RICO claim, right?
Well, if they establish a pattern of racketeering activity.
Well, I mean, no. If they violated the bingo statute, it would be RICO, right? If they did two or more predicate acts, right?
And there was an enterprise, Your Honor. Yes, Your Honor.
Well, that's not hard to prove if there's an enterprise.
Right? Exactly, Your Honor.
Pretty broadly defined.
Well, I would just like to point out that on the issue of the leases, for one, the defendant said that at least the halls for 1 or 2 hours, but I just want to point out that's illegal. You have to have a lease with each of the lessees for an entire year. So their argument about this being lease rental income is...
Let me ask you this question. Is it your position that you could have brought this action just as to the halls that were the subject of the prior action and just as to the defendants that were defendants in the prior action, simply because you changed your legal theory from it's a direct violation of RICO to it's a violation because it's a violation of federal RICO and it gets brought into the state action now?
Are you asking if we could brought, like the same question, whether we could brought it in federal court?
No. Could you have brought this action if you hadn't added the additional bingo halls and added the additional defendants?
Well, no, because then it would have been the same exact pattern of racketeering. Here we have a pattern of racketeering that's different.
Okay, and the pattern of racketeering is different because you've added additional bingo halls, correct?
Right. And I would say...
So let me ask you this. You brought in, what, 13 bingo halls?
Yes, Your Honor.
Could you add them one at a time until you finally won? If you didn't win with 2 of them, could you add number 3, go to trial? If you didn't win, could you add number 4, go to trial? If you didn't win, add number 5 until you finally won one?
Well, if they kept breaking the law, Your Honor, what they're saying is, what they're saying,
pattern is not just 2 bingo halls, now it's 4 bingo halls, and that's a different pattern of racketeering. That's your theory, right?
Your Honor, under Campbell v. State, which is another 4th District Court of Appeal case,
Campbell didn't involve gambling or lottery or bingo.
Well, it involved race judicata, Your Honor. But they said that a prior that it was clear that a prior case could not be raised judicata to a subsequent RICO case that alleged continuing offenses committed after the prior case, even though they shared some facts.
Okay, so if it's your position, these 13 bingo halls are all doing the same thing, and that's a violation of RICO, you would have the option to keep bringing new actions, adding one more each time until you find one.
Well, the standard for res judicata is claims that could have been brought, and these claims could not have been brought. For instance, the jury verdict only implicated 2 of the halls that weren't even implicated at all in the first action. The facts necessary to maintain the suit against those 2 halls that were actually forfeited and the 11 other halls are not the same facts necessary. That's the standard. The facts necessary.
By adding a different day or a different party, you could go ad infinitum against these parties?
It would be, in other words, yes, Your Honor. In other words, if John Gotti got off for, prostitution on a pandering charge for this, for this here, but then
From
you had,
March to June, and then from June to July, and then from July to August, and then from August to September, or from August 1, August 2, August 3, August 4, each is a separate RICO violation involving multiple parties, as long as you do a different date or drop or add additional
right,
parties.
yes, Your Honor. According to Campbell versus State, in other words, they were breaking the law after 1994 when the other action was filed in 13 other halls. So the Attorney General filed an action. The State Attorney actually tried to consolidate. We tried to bring the cases together, but the judge denied that. So,
If you brought all 13 in on the original lawsuit,
well, he
where
tried
you
to
were claiming that the violation of the state bingo statute violated state RICO, you brought all 13 in originally, and it had come to the same result in the Supreme Court. That is, you can't violate RICO by simply violating the bingo statute. Then you could turn around and sue the 13 again because now you have a new theory. It's not a direct RICO violation, but it's a violation of the federal RICO, and that backdoors into the state RICO. Could you do that?
Right. If they break the law, they form another pattern of racketeering activity.
Same activity that you say violated it before
Right,
and
but
you
it didn't
lost
happen
on
yet. It didn't happen yet. So
But the same activity, the same nature of the activity, even though it's a new date. Your argument, the tip jar, the way the charities work, that's a violation of federal RICO. You lost that argument. So the same activity a month later or a year later, now you can say, same activity, same RICO statute, but a new lawsuit, because I have a new theory now, I can backdoor in through the federal RICO statute. It's not a direct violation. You could do that.
yeah, they committed a new pattern of racketeering activity. What they're saying
It's the same pattern of activity that you already lost on once, right? The Florida Supreme Court said that pattern of activity doesn't violate Florida RICO, right?
Well, it wasn't a lottery statute. They just answered the certified question. They didn't have the facts before them, Marine. They just answered a certified question based on the way the states, in this case, the way the state's action was originally framed. We had as all parties do, have the pleasure of amending our complaint.
Does the record show that there were other parlors, not these, that were the subject of the RICO violation that you allege here? That is, the federal statute now makes it a crime in Florida.
I'm not sure I
The
understand.
record below, the record on appeal, does it show that there were other violations not involving these parties?
You
Of the
some of
RICO
cases?
prosecution, yes.
Different cases?
Yes.
Well, yeah, they think the defendant spoke about some other actions, some other. I mean, there was a criminal trial as well. Am I answering your
Do you
question?
want to, no, you didn't, but do you want to address the damages issue as to the corporations?
Oh, yes, Your Honor. As far as damages, I can say as succinctly, even if you reverse the jury verdict, this court is unable to award them damages because under the motion for damages, which is 60.07, which is the only means by which you can receive wrongful injunction damages in the main suit, there has to have been an injunction bond posted. And the reason that is because under 60.07, the litigant must look to the injunction bond as the sole source of recovery.
Isn't there some case law that says, however, if there's no bond, there's no cap?
Well, yeah, but you have to file a separate action. You can't get any damages whatsoever under 60.07, which is a motion in the main suit. It says the only method of seeking wrongful injunction damages in the main suit is a motion under 60.07, which they filed. And so the judge did not err. He was compelled, even if, I mean, he had other reasons because of the jury verdict, but this court cannot award them damages at all because it's not available where there's no bond posted.
Any case law, or is it just out of the statute?
Oh, yes, there's case law, Your Honor. It's cited in our brief. I don't have it right here in my outline, but it's cited in the brief, Your Honor. It would be error for this court as well. It would have been error for the trial court to enter a judgment for damages because and I would say it this way, even if the court could have erroneously granted their motion, their damages would be zero because there was no bond. So they would have to file a separate action.
Did the Supreme Court in the prior case require that a bond be placed with the court clerk?
Well, the Supreme Court upheld the discretion of the trial court. The state appealed the discretion of the trial court imposing a bond. The Supreme Court upheld his discretion, and when that happened, we didn't post a bond, and so the injunction lapsed. That's the luxury of any litigant. If a bond is required and you don't post it, then you ride without a bond on your injunction. Because he required it and because the Supreme Court upheld that discretion, the state elected not to post a bond, and the injunction lapsed.
Thank you, sir. That ends your argument. Gentlemen, you've exhausted all of your time. Thank you very much. Well argued. We'll